Hot Business on Hot 102.7 with Jeremy Maggs and MoneyWeb.
So often if you talk about matters governance, people's eyes tend to glaze over. I think that's fair enough, but this really is important. We are not doing enough, says the Institute of Directors in South Africa, to hold delinquent directors accountable. And that is having a potential knock-on impact on the overall state of governance in corporate South Africa. Vikeshni Vandayar is the Executive Governance and Corporate Services at the Institute and joins me on the program tonight. Vikeshni, good evening to you and thank you very much for joining us. I'm not being disingenuous about governance. I know it's important, but it can be a little dull sometimes. So let's focus on delinquent directors themselves. What are they, and in what respect are they not being held accountable, do you think?
Well, good evening, Jeremy, and thank you for that question. So delinquent directors, in plain language, is basically individuals who are breaching their fiduciary duties as a director. That means they're not acting in the best interest of the company, and they're not acting with the proper due care and diligence that's expected of a director in that position. And the impact of declaring someone delinquent was created by the Companies Act to actually help ensure that such individuals are prevented from serving on any other board. So it's actually a mechanism to help us ensure that these individuals don't continue to cause disarray in other organizations where they're found, to be conducting themselves unwanting.
How serious or benign is the problem? Is this sometimes due to incompetence and not understanding the role that a person has to play as a director, or is it simply about self-gain and malfeasance?
So I think there's both scenarios. At the end of the day, individuals who wish to defraud or steal are going to do that, irrespective of what governance frameworks you may have. But if we look at, your current corporate and governance failures, a lot of the insights or lessons show a clear lack of understanding of corporate governance and just as director duty. So I think it's two-pronged. There's individuals on boards who don't have the requisite depth, knowledge, and experience to be on the board to properly understand why they're there, because you do need courage to also speak up, I think, and challenge what's being put forward. And there is individuals who are just there for the wrong reasons.
So the impact then of directorial misconduct on companies, and obviously the domino effect as far as stakeholders are concerned, what have you been able to determine in that respect, particularly in terms of cost to company?
So obviously the impact is great because, as we've seen with the maladministration in a lot of our SOEs, there's the impact on your company's performance, the reputation of the company, clear public interest to the stakeholders, the employees, or just the public at large in terms of where we've got state-owned entities that need to be providing a service delivery. So the impact to the company itself is huge. So companies do need to act, I think, swiftly where these situations are identified. But what we've found is, although there are a few cases where we've had some director delinquency declarations, that the biggest one being the Dudumiyeni case, often I think companies tend to settle out of court. And that's for various reasons. It's the cost of bringing a legal application. It's the potential reputation and the length of time that a company may have to go through things, especially where there's a legal battle. So it's often quicker, it's easier, it's the most pragmatic decision to remove a rogue director, part of a settlement agreement or quietly. The problem with that, though, is that it doesn't really help SA Inc. in the sense that no one is aware of the disciplinary hearing or the issues as to why that director was removed, and that individual then can simply continue, serving elsewhere.
And that happens quite often, I imagine, given that there is a lack of will to perhaps be more pronounced in terms of identification and punishment.
So from what I've heard from my colleagues who wrote the paper, that because we released a paper on direct delinquency, they indicated that it happens more often than not. But I think we can see in the current public domain, there's definitely a rise for accountability and for taking action. And I do think we have regulators and institutions like the CIPC and IOTA who are geared and are aimed at taking these investigations forward, especially if the companies themselves do not want to. So I think we do need to actually support the CIPC, etc., with their investigations.
I know this is a real generalization, but shouldn't directors themselves sitting around that boardroom table also be a little bit more awake to aberrant behavior and just noticing what's going on instead of just arriving, attending the board meeting, collecting the fee and moving on?
Yes, definitely. And what we've seen in the Dudumieni case there was the court also held, you can't hide behind collective decision making. You're part of that board, and individuals themselves in that board can be held, liable for what's, the decisions. So as a director, you should be fully aware in terms of mitigating situations that you can use in terms of decisions made. You need to make sure you're fully aware of the circumstances, you're informed before you make a decision. There's no conflict of interest. And like I mentioned, you definitely need to have the courage to be able to challenge decisions being made and make that noted in your minutes, because that's your defense, if you don't agree with the resolution being made. But I think definitely that culture of groupthink or a group agreement is something that needs to be addressed. And I think certainly some of the reasons for some of the failures we've seen due to the board composition and lack of independence and objectivity on board. So I think it's very important why when we're looking at board composition, we're looking at individuals that can bring that independence and objectivity.
It's not just composition, it's also understanding the awesome responsibility about sitting on a board in terms of fiduciary duty and general responsibility. And the sense I get sometimes is that people are underqualified. They are so delighted to be sitting on the board, yet they have very little understanding of what it entails and what the responsibilities are.
You're absolutely correct, Jeremy. I think, one of the problems we have is that in terms of law, anyone can serve as a director. There's no minimum criteria or requirements. We only have certain situations which may disqualify a person to serve. So we definitely need to zone in more, both private and public sector, in your board charters or wherever it is. Clear distinction around what are the minimum requirements that you can enforce for a director to be appointed. So that's, looking at their experience, the educational requirements, professional designations, for example. Are they a member of a professional body? Because without those minimum criteria in that nomination process, we run the risk of appointing people that don't have that necessary experience. At the IoDSA, we've been advocating a lot for the professionalization of directorship. We do believe, directorship should be seen as a profession, like any other. There needs to be a set standard and skills and knowledge that's required. We always say you can be a great lawyer or an accountant or CA, but you don't necessarily are going to be a great director. So, training is very important. Taking that career, if you want to go that route, you should look at getting a director designation. It shows your commitment to understanding what your role is and ensuring that when you're on that board, you're gonna do the right thing. You're gonna lead ethically and effectively. That license to operate, we've said, I think is key in terms of what we need in South Africa. There should be a license to operate as a director, and if you're a member of a professional body like ours, check if they are a member, because then you're also bound by our member code of conduct. And then one last thing, I think, irrespective of due diligence practices or whatever you do in terms of selecting, competent members, continuous professional development and training is also key. Like you mentioned, if you want to take up this role, you need to make sure you understand your fiduciary duties, but you also need to be keeping up to date on latest developments that may impact your board. You need to be able to objectively provide that oversight and question the information that's being put before you, as a board member. And And also board inductions by companies. It's not just about understanding the business. Boards need to ensure those new members understand what their standard of conduct is expected of them. What's the values and what they're going to be held against before they even step into that boardroom.
As I said at the beginning of this conversation, not always the sexiest subject when it comes to corporate South Africa, but absolutely critical. And thank you so much for that very important and valuable insight, Vikeshni Vandayar from the Institute of Directors South Africa. I do appreciate your time tonight.
Heart Business on Heart 102.7 with MoneyWeb.